Good morning, everybody. I am very grateful for the IHSS program that we have here in the state of California. Administered by the Department of Social Services, it is arguably one of the best systems we have in our country. But it's not perfect. The function of our discussion today is to make you all aware that CDSS rules, regulations, and clarifications are not always consistent with each other. Although many examples can be made, we're going to focus on three categories. Before we start, I want you to understand that the courts have given administrative agencies great latitude in creating and enforcing their regulations. The following three statements have all been affirmed through either federal or state superior court rulings. Number one, an administrative agency's interpretations of its statutes and regulations governing the IHSS program are entitled to great weight and deference, which means they get to essentially make their rules. And the court systems will not touch their interpretations of the rules. Number two, the courts have held that an agency's interpretation of its own regulations is the ultimate criterion, which becomes the controlling weight unless it is plainly erroneous or inconsistent with the regulations. Number three, similarly, our Supreme Court has held that a court may not substitute its independent judgment for that of the administrative agency on the facts or on the policy considerations involved. So the point we're making here is that the administrative agency has the ability to essentially make their own rules in governing their program. However, if those rules are plainly erroneous or inconsistent with the regulations, they can be overturned. So we're going to focus on three different categories and provide examples for each of those categories in order to explain to you exactly what we're talking about. So example number one is in the situation when a regulation conflicts with a statute. Now, a statute is a law. It's enacted by either a state or federal legislature, and it's signed by either, if it's state, a governor, or if it's federal, the President of the United States. A regulation is a policy or procedure implemented by the administrative agency. A regulation can be an interpretation of a statute. However, it cannot contradict the statute. And the example that I use to demonstrate this is very current. Disability Rights of California was recently successful in eliminating the proration rule for protective supervision. And the vehicle they used in order to overturn this in their stipulated agreement was to make an argument that the proration rules violated the American with Disabilities Act. And of course they were successful. Example number two would be when two clarifications based upon the same regulations conflict with each other. Can a recipient exhibit both non-self-directing behavior and excluded behavior and be granted protective supervision? That is our example we're going to use to demonstrate this principle. Regulations do not expressly state the ability to do so. All County Letter 1525 states yes, but All County Letter 1795 states no. The background. Manuals of Policies and Procedures 30-757.172 establishes protective supervision shall not be authorized for friendly visiting or social activities when the need is caused by a medical condition and the form of the supervision required is medical, in anticipation of a medical emergency, to prevent or control antisocial or aggressive recipient behavior, or to guard against deliberate self-destructive behavior such as suicide, or when an individual unknowingly intends to harm himself or herself. The regulation is an administrative agency's policy and procedure. However, as previously stated, it does not provide expressed authority to deny protective supervision when non-excludable evidence of non-self-direction is also present. ACL 1525 was initiated by CDSS on March 19, 2015. It contains the following citations that clearly demonstrates that it is permissible for a protective supervision recipient to exhibit both excluded and non-excludable examples of non-self-directing behavior. Now the section I'm going to recite from is under a subheading, mentally impaired mentally ill, and non-self-directing. And it states, in addition to all other relevant eligibility criteria, a person must be both mentally impaired or mentally ill and non-self-directing to be eligible for protective supervision. It is not sufficient for someone to just be mentally impaired, mentally ill. There must also be evidence that he or she is non-self-directing. This policy is based on the court rulings in Marshall v. McMahon and Calderon v. Anderson, and will be reflected in forthcoming amendments to the protective supervision regulations found in MPP 30-757.17, which, by the way, has never been done, just FYI. The exclusions listed under MPP 30-757.172 are applicable if recipient is otherwise eligible for protective supervision and that he or she has the requisite mental impairment, mental illness, is non-self-directing, and would likely engage in potentially dangerous behaviors. Expanding on the item listed above, if a recipient only displays needs or behaviors excluded under MPP 30-757.172, they are not eligible for protective supervision. If a recipient displays excluded behavior based upon MPP 30-757.172, they may still be eligible for protective supervision for the non-excluded behavior. So essentially what the clarification is stating is that you bifurcate off that behavior which is excluded and you continue on with your examination with the behavior that is still worthy of protective supervision. But in contrast, ACL 1795, initiated by CDSS on September 12, 2017, provides an advisement that contradicts the advisement noted in ACL 1525. Whereas ACL 1525 clearly demonstrates that it is permissible for a protective supervision recipient to exhibit both excluded and non-excluded examples of non-self-directing behavior, the semantics of the advisement in ACL 1795 suggests that any example of excludable behavior disqualifies any potential protective supervision applicant, regardless of the presence of any quantity of non-excludable examples of non-self-directing behavior. And now I'm going to read from the subsection. This is from ACL 1795. It's a subsection, Antisocial and Aggressive Behaviors and PS Eligibility. And it states, assessing PS eligibility due to a recipient's minor or adult competitive behavior shall be evaluated based upon the willfulness of that behavior. As with all services, the recipient's age and specific behavior shall be considered. When assessing for PS eligibility, a recipient must have a mental impairment, mental illness, and determined to be non-self-directing due to the mental impairment or mental illness. The recipient would be considered non-self-directing if he or she is unable to assess danger and the risk of self-harm. A recipient who meets these criteria and displays self-destructive behavior, such as headbanging, as a manifestation of a mental impairment, mental illness, may be eligible for protective supervision. However, a recipient who has a mental impairment, mental illness, and is determined to be non-self-directing due to the mental impairment, mental illness, but exhibits antisocial or aggressive behavior, and it gives examples of pulling hair, scratching, hitting, directed to harm another individual, would be ineligible for protective supervision. Ineligible. That's different wording. That's strong. That's an instant kill pill. That's essentially giving the social worker the ability to, as my partner David Wolf says, deny protective supervision because Billy hit somebody in the first grade, and Billy is now 14 years old. That's not fair. That's not the way the regulation is supposed to be. Additionally, a recipient who displays intentional self-destructive behavior with knowledge that the activity may cause self-harm would not be PS eligible. This type of behavior may include tantrums or headbanging as a way to achieve a desired result. In this case, the recipient would be considered self-directing, as there is knowledge that the activity may cause self-harm. Therefore, he or she would be ineligible for protective supervision. Now, we believe the advisement in 1795 runs contrary to CDSS regulations for several reasons. Number one, the advisement found in ACL 1525 do not automatically result in protective supervision approval. Any concerns about the remaining evidence of non-self-direction would be examined in the further steps of the process. In contrast, the advisement found in 1795 do result in instant termination, even in situations where the excluded behavior is a tiny fraction of the evidence of non-self-direction. Number two, the advisement found in 1795 effectively creates an evidentiary standard that is greater than that of a shadow of a doubt, whereas CDSS regulations indicate the intended standard evidence is preponderance of evidence. Number three, the advisement found in ACL 1795 effectively blocks a minor's consideration of the principles agreed to in the Garrett versus Anderson's court stipulated agreement. Many of these principles were also adopted into CDSS regulation. The advisements discussed in ACL 1525 are very reasonable and do not necessarily provide protective supervision to an otherwise unserving recipient. In contrast, the advisements in ACL 1795 do potentially deny protective supervision to otherwise non-self-directing individuals, as described in Calderon v. Anderson. We have seen multiple cases with multiple pages of examples of evidence of non-self-direction taken from relevant documents routinely denied solely due to the presence of an unspecified quantity of excluded behaviors. So that's an example of where you have a contradiction of two clarifications from two different all-county letters, in this case 2 years apart. Example number three is, what happens when you have a regulation that has certain semantics, but that when it's clarified at a different point, the semantics are changed? So here's my example for this. In all-county letter 1795, discussing alternate resources. Alternate resources are considered to be supportive services which may be available from other agencies or programs to meet the needs of the recipient as assessed. The county shall arrange for the delivery of such alternate resources as necessary in lieu of the IHSS program funded services when they are available and result in no cost to the IHSS program to the recipient, except as provided in section 30-763-613. So it includes examples as being not limited to adult daycare centers, schools, community resource centers, senior centers, or respite centers. However, when you look at the actual manuals of policy and procedure, which they are citing, 30-757.171A subsection 2, you will discover that school was not originally listed as an example as an alternate resource. As a result of this clarification, changing of the semantics, I am sure many of you have seen a reduction in your IHSS hours due to personal care services being provided at school. The regulation does not give a social worker an expressed ability to make this deduction. It is the interpretation of the regulation that allowed this to happen. In closing, this advocate is aware of several inconsistencies within IHSS policy and procedure and is working with the Law Office of James Diskant through submission of writ requests in Superior Court to get objective clarity to these inconsistencies. I was advised by my mentor, Charles Wolbinger, many years ago that CDSS has the ability to change departmental policy through the use of modified regulatory interpretations. With this being said, please understand that there is value in pursuing the overturning of an IHSS protective supervision denial with the assistance of an expert who has encountered similar issues on countless occasions. This is definitely an arbitrary process. Any questions?
So just go ahead and let them know if they have any questions for you to put it in the comment box. We did get a partial question from Shannon Shoemaker. So Shannon, if you can finish your question for Larry. It says, "Hi Larry, we're starting this process. Our son just turned 5 and has severe," and then it ends there. So
Okay. So let me scroll down here. That's the only comment we have, huh? So far?
just give everybody a couple seconds. If you have questions, please type them in the comment box. Oh, you go ahead, Larry, you saw it.
Okay. What does that say?
This is about 42 USC 1396 and as a IOJ.
So I'm not familiar with that citation specifically off the top of my head right now. So if you can be more general and let me know specifically what area you're talking about. I will say this, that the reason why we chose this particular topic, approximately 2 weeks ago, there was a discussion within the IHSS advocacy group in terms of the semantics from the provider notice of action, which states that it's a responsibility for the caregiver to notify the social worker when the recipient is in the hospital. But in fact, if you look at the actual regulation itself, what it states is that if the provider wants to be paid for a time when the recipient is in the hospital, they need to contact the social worker. And I'm of course summarizing what it says. And the semantics are completely different. One of them is putting the burden of reporting on the caregiver, and the other one is stating that the caregiver is essentially requires additional permission to be able to provide services that are outside the home.
So Shyla Duke, who asked you the original question about that citation, continued on. So is this about the citation in-home supportive services, personal assistance support services, self-directed care? So does that? If not, we have a couple other questions we can.
Yeah, that's still very. I'm sorry. I apologize. I'm not understanding what the question is on that. I don't know if there's a specific.
So we'll go back to Shannon. She was the first person who had the incomplete. So they're starting the process. Her son is turned 5, and he has severe autism, a genetic disorder, DDID, nonverbal, unable to self-direct, severe cognitive delay. He has an IEP which states he is approximately 12 to 18 months cognitive and overall skills. My son headbangs, pulls hair, scratches, pinches, a lot of others. He does these to himself. He has no understanding of danger.
Okay. And then what's the question? So that sounds like an individual, in my opinion, that would be worthy of protective supervision. But I wanted to make it clear once again that this is an arbitrary process, and that just like we mentioned with these 3 examples that we gave earlier, the regulations are the concrete wording, and the clarifications are the interpretations of the regulations. And giving an example, one of the issues that I run into, and that I'm actually working right now with James Diskent, the attorney I referenced before, to have the superior courts look at, is this idea of whether putting inedible objects in the mouth is considered to be an example of a medical emergency. The regulations don't actually provide specific examples. It's a clarification that's found in All County Letter 1525 that seems to imply that a medical emergency would be something like having a heart attack or a stroke. But yet, recently we've seen a number of examples where ALJs, judges, have denied protective supervision because they consider the act of an individual putting an edible object in the mouth being a medical emergency of choking. And of course we disagree with that logic. So like I said, the regulations and the interpretations of the regulations are very arbitrary.
Okay, another question from Dallas. The examples given were directed towards minor children. Can the regs noted in some ways apply to adult recipients, or are there specific regs and cases applicable to adult recipients? No, the logic that we use is that if it's going to apply towards a minor, it's going to apply towards an adult. And in fact, I believe it's, if I remember correctly, it might be in All County Letter 1795. It actually makes a reference to the fact that, at least in some respects, the rules from the Garrett order, even though it's designed specifically for minors, it still applies to adults. Okay. So, hi Larry, thanks for holding this session. This is what is ACL 1795 refer to? Currently, we have protective supervision and mostly on non-self-directing and mental impairment condition. IHSS usually reassesses and always denies protective supervision, saying home is safe, it's social visitors. How do you fight that because it's not true?
1795 has many citations in it. We've included two of them here today. We've included the citation that discusses the alternate resources, which included the term school. We also discussed what we believe is a incorrect interpretation of the regs, in which allows a social worker to deny for excluded behavior, even if it's as small as one occurrence, even in the face of a long list of otherwise non-self-directing behavior. How do you fight that? Well, you fight it by filing a request for hearing, and you put together a argument in your position statement, and you make your argument and you convince a judge. That's the way the process works. And if the judge denies you, you can have the hearing unit review the case and determine whether or not the judge's finding is consistent with the regulations. And if the regulations, if the rehearing unit finds that the regulations are consistent, then you can take it to the next step and have an attorney file a writ in Superior Court and have a third party, someone who is not actually affiliated either with the county or with the state in terms of CDSS, have them look at the matter and see if in fact the agency did follow proper procedure, or if it's a violation of any of the three categories that we talked about here today.
Okay, so back to Shannon. She has her question. This is the 5-year-old.
Okay.
My question is that I know he should qualify, but I am worried about not describing it correctly. Oops, wait. We have to be at home with him and just found out that we can maybe receive help. So my son needs to be watched because he will eat anything that isn't edible. He will eat his own poop if I don't catch him right away. That is considered a medical need, not a protective supervision issue.
So it's funny you should mention the fecal matter, because I actually have had, there's one specific ALJ who has made a determination on 2 different occasions in cases that I've been involved in, where he has made a finding that eating your own fecal matter is safe, because you're not going to have the bacterial reaction to it that you would have if you ate someone else's fecal matter. I think that's absolutely absurd. That's actually one of those issues that like I said, that myself and Mr. Diskant are working on filing writs for, in order to get clarification from somebody that is outside of CDSS. Other than that, I don't have a good answer for you. The program's arbitrary. That's the reason why you would use an advocate versus do it yourself is because an advocate has knowledge of the regulations and has experience in navigating through these issues and can put together a legal argument that is persuasive in order to potentially get an ALJ to rule in your favor. But ALJs are like everybody else in the world. They have their particular beliefs, and some ALJs are very conservative and some are very liberal. And so, a lot of time, the determination of protective supervision does come down to, the mindset of the judge.
Is there any way you can address her question about that she's worried about, she's not, question is, well, I'm sorry, I'm scrolling to get back to it. She's worried about not describing it correctly with the head banging and the scratching and so forth. So I don't know if you can give her some advice on that one.
Okay. So I have a philosophy that I use, and my partners know this very well. So I believe that when someone's asking for a service like protective supervision, it is essentially equivalent to someone saying the sky is falling. And so when somebody is in a panic mode, the sky is falling, they're going to be screaming at the top of their lungs, I need help. And so as a result of that screaming for help, they're probably going to scream help to their doctor, to their ABA therapist, to regional center workers, to the social worker from IHSS, to many different people, to the school district. And so if in fact these issues are something that is severe enough in order to warrant protective supervision, there should already be a record that's been created as a result of your yelling, "I need help," and of these other agencies not necessarily viewing it themselves, but that you've reported it. So it should be, listed in your IEP at school. It should be in a regional center document. It should be something that your doctor references when they fill out the SOC 821. It should be something you told the social worker at the assessment. It should be something that perhaps maybe is in an ABA report. And so when you go through to establish these concerns, it's not so much that you say it, it's whether you can validate that you have said it to other people in the past. That's actually far more important, because that establishes your credibility as a witness when you actually present in the hearing. A lot of times judges will dismiss a claimant's testimony if it's not supported by other documents, and the logic is very valid. Like I said, if this is something that is such a high concern of yours that you need help, it's logical that you would have told a lot of different people about it, and they would have written it down in these third-party reports. And so in terms of saying the right things, it's not so much what you say, it's more what you can validate through the third-party documents. Does that answer the question?
I believe so.
Okay.
Shyla, she had a question about what is protective supervision, and does this only apply to California?
It is California, because IHSS is a state program, and protective supervision is one element of in-home support services. And what I'd recommend doing is, if you're interested in learning more about IHSS, you can Google it. And Disability Rights of California, the same organization that overturned the proration rule, actually puts out wonderful literature. And they have one that is all about protective supervision. I do believe it's also on our website, if I'm not mistaken, IHSSadvocates.com. That'll give you all the information you need to know about IHSS.
Okay. Another question. In Orange County, the social worker regularly takes away hours for alternative hours such as schools, daycare. How do we inform them that it's incorrect? What is the MPP ruling the recipient can use to counter this?
The MPP does not include the word school. That's actually one of the things we discussed in this presentation. So the actual MPP, the Manual of Policy and Procedure, that is used by CDSS does not actually include the word school. It is, however, in the clarification, which is in 1795. And so they're going to rely on the clarification. So the only way that you could possibly get this reversed is to make two arguments. First argument is that it's not part of the regulation, and that the ALJ should rely on the regulation and not on the clarification. That's number one. But number two, which I think is even more important, is you, as the authorized representative for the minor child, have the choice of picking when the hours are distributed throughout the week. And so you can elect to not use the time at school as part of your IHSS. So if you're authorized, say for example, 5 hours of dressing, this is just a hypothetical. The social worker cannot force you to use some of those hours at school. The social worker can recognize school as an alternate resource, absolutely, so you cannot get paid for time while your child is at school, but you're not getting paid for when your child's at school. Your child's just getting a resource provided for free by the school district. They should not dock you for the hours at school if in fact you can validate that there is a need for those hours in other places, because like I stated before, the law says that you, as the authorized representative of the minor, are the one that determines how the hours are used. All the state does is grant you a certain quantity of hours for certain categories, and the total of those hours is quantified in an amount that is designed to be administered over the duration of a month. So you have the ability to determine where those hours are allocated. So that's the argument that I would make in that situation, is I would argue that, yes, you recognize that school is a time in which you cannot get paid, but it doesn't specify, the regulations does not specify that the school district must allocate hours from IHSS for school. You're not supposed to be docked hours because the service is provided by the school district. It's supposed to be an alternate resource, which is essentially a neutral point, a point in which you can't claim time, but it should also not affect your hours that are authorized for the month.
Okay, another question from Nicole Renee. My daughter is homeschooled and she receives protective supervision. Can this create problems?
No, I don't see why that would be a problem. Let me clarify. So the child's already got protective supervision?
Mm-hmm.
And so are they afraid they're going to take it away? Because obviously if they got protective supervision and the child's homeschooled, they obviously got protective supervision while the child was homeschooled. So I'm not understanding the question. Are they afraid they're going to take it away for that? Because no, they can't. If you can still establish that there is a need for protective supervision for time in the home, school should be off limits. And in your case, school is at home. So yeah, you would simply report to the social worker during the assessment that the same behavior that happens during times in the home that is not related to school also occurs, I would assume, I'm assuming this is true, when you're doing your homeschooling. And so, yeah, there should be no reason why that they would take it away for that reason.
Okay, so Sonya, the social worker argued that my daughter can dress herself as indicates on her IEP and that she can adjust her clothes. But my point of view is it did not say she can put her clothes on. Can they take away hours for her dressing?
How old's the child? Age would play a factor in that.
Okay, so maybe Sonya can put that in comments. Another question while we're waiting for Sonya from Shannon. Is there any information for advocates in your area who can be hired? I'm in Sacramento. Okay.
IHSS Advocates, that's the firm in which I'm a managing partner with. We do the entire state of California. We actually do our administrative hearings over the telephone, so we're able to represent families all across the state. I typically don't like to self-promote myself. I like to let the people that have used me promote me instead. In fact, I would imagine that if I would ask those people that are watching this that have used my services in the past, if they could please, respond so that this person knows the type of representation that my firm presents. I will tell you that since you've already asked the question, over the last 10 years, we've been successful in overturning approximately 600 protective supervision denials, I've been doing this for a while. My own son was diagnosed with autism. I got him protective supervision. He was actually my very first person I got protective supervision for, simply because it was my family member before I was actually formally an advocate. IHSS Advocates is my firm, and if you're looking for an advocate in Sacramento, look at the website, or you can even send a message to us, and we'll respond.
Okay, Sonya came back that her daughter is 5 years old. Do we need to read?
Yeah, age 5 is the cutoff for dressing. So there is what's called a functional index ranking scale, and there's also what's called a Vineland scale. The functional index ranking scale is hours that are determined based upon whether or not the social worker ranks your child's need as a 2, 3, 4, or 5. And even in those categories, there's low, medium, and high. And so the amount of hours they authorize can vary. But then with the Vineland scale, they've determined that all children at certain ages require parental supervision or parental support in order to perform certain tasks. And dressing is one of those categories that opens up at age 5. So my question to you is, was your child age 5 when you had this issue? Because that would make a difference. Age 4, the social worker is not typically going to authorize hours for dressing, but age 5 they will. And so is that the issue here? Is that the reason why? If there is any type of a deficit whatsoever in regards to dressing at age 5, they should give you some hours. Now it sounds like from your original response that there are some functions that your child can do, but there's some functions your child cannot do. Well, a typical 5-year-old child is expected to be able to do all the functions. And so if in fact there is something that your child cannot do, and other things your child can do, well then the ranking would be lower than versus higher, but you still would be able to get hours for that. I hope that answers your question.
So Loy has a question. My son was denied for IHSS services and we appealed. The appeal officer offered us conditional withdrawal for reassessment because she thinks social worker was wrong in denying us. And we agreed with it. Did we make the right decision to agree with the social worker?
Absolutely. Absolutely. So you have 2 chances to win now versus 1. And you have an opportunity now for you to go back and to essentially allow the social worker to review the documentation that you've already presented, maybe even give some new documentation. Maybe the social worker will come out and do an in-home visit. I'm not sure with COVID and all, but yeah, you have an opportunity now for your social worker to give a second look at the case. If you don't like the outcome, then you can file another hearing request based upon the new notice of action. So yes, absolutely. In fact, that's part of the strategy that we use as advocates. When we take on cases, we put together documentation that we believe may have actually been excluded from the initial assessment and present it to the social worker weeks ahead of the hearing and give them the option of reviewing the information and possibly doing a conditional withdrawal. So absolutely, you did the right thing.
Okay, a question from Rita. What changes when your child becomes 18 in terms of protective supervision?
So at age 18, the child is no longer a minor. So at age 18, the rule that says that in order to be a provider, a parent has to either be barred from full-time employment or prevented from full-time employment or left full-time employment is no longer a rule. That's number 1. So if you happen to be a parent provider and you've been forced to work a part-time job because of the need to care for your child, you can now go full-time and they can't do anything with your hours. That's one change. There's also other hours that are available to you at age 18. They're going to be your domestic and the majority of your related services. Those are going to be things like house cleaning. We don't live in the north, but potentially if you were in an area that had snow, clearing snow, it's those things that you would expect a homekeeper to typically do in terms of the care of their home. It's off limits to minors because it's assumed that the adults who supervise the minors would be responsible for those duties. But at age 18, obviously, when the recipient becomes an adult, obviously that's not the case anymore.
So Rebecca just sent in a question. My worker wants to take away hours because while my child is back at school. I guess that's what she put. I guess the question is, can they take away hours when the child's back at school?
Well, this is, like I said, this is one of those things where you need to make an argument. My personal opinion is no, but I do know that the social workers rely on the clarification from All County Letter 1795, where they have included the word school in the clarification from that regulation in order to allow them justification to do this. My position on this, as I stated before, is it's the authorized representative of the recipient, which is the parent. It is they have the choice of how the hours are administered. And so they're not required to use the hours during times when the child's at school. They can use those hours during times in which the child is at home. This is supposed to be in home support services. It's not supposed to be at school. And so given the fact that school is an alternate resource, if in fact that's the angle that you want to go based upon the clarification, we make the argument that the school is providing those services for free and that there's no need to dock the family for those services intended for the home while the child's at school. That's our position. But it's arbitrary. This, I wish I could sit here and tell you that it's just really simple and that the rules are just absolute and they're always going to be followed 100%, but that's just not the way it works. That's why there's judges. You can have two different social workers or two different judges and have the exact same material and have different outcomes. It's an arbitrary process. And as I stated before, if in fact you don't like the outcome of what your social worker does, you file an administrative hearing. If you don't like the outcome of what the judge does, you file a rehearing request. If you don't like the outcome of the rehearing request, you can always hire an attorney or retain an attorney and take it to Superior Court. The reason why I like James Diskent so much is because his cases that he takes on, he gets paid by the state for taking them to Superior Court. So he doesn't charge you anything extra when you have to go to that last leg. But unfortunately, attorneys don't get to collect their attorney fees in administrative hearings. So the only point in which you can actually have an attorney work for free, and it's not really free, but I use the word for free, would be for matters that go to Superior Court.
So we have, it's almost 12:45, so we have a last question in here from Rebecca, the same lady. What are the rules in a two-parent home?
Didn't we just do that? That was a presentation we just did recently, wasn't it? Did we do the two-parent rules?
Yeah, I guess we can find the video.
Rebecca, if you have specific questions on this, you're welcome to reach out to me personally. I do believe we did a presentation on this just recently, and I'm almost positive that it's going to be already on the group. So the rules for two-parent homes, a parent can be a provider for their minor child if there is no other able and available provider, if the care that's needed would otherwise result in out-of-home placement, and if the parent themselves are either prevented from full-time employment or have left full-time employment as a result of caring for the child.
Yeah, Tim just sent her the link, so all good,
Okay,
Rebecca.
very good. Thank you.
So I guess that's it. That's
Okay.
the last question, so thank you.
Very good. Thank you very much, everybody.